Hi, my name's Clare Murray, and I'm managing partner of specialist employment and partnership law firm CM Murray. And I'm absolutely delighted today to be speaking with my new partner, Andrew Pavlovic, who is a specialist SRA professional discipline and regulatory lawyer. And we are going to chat about the current SRA consultation. And would you mind just giving us a very high level sketch of the issues that the SRA is consulting on with the legal profession, please?
Yes, so there are three particular areas that I wanted to focus on in the SRA consultation. It's a general review of their finding powers. The first one is the SRA are seeking opinions as to whether certain types of conduct are suitable for a financial penalty, and in particular looking at sexual harassment and discrimination. So in circumstances where a solicitor has been found guilty of sexual misconduct, whether it's appropriate that they should receive a fine, or whether a more severe sanction, such as a suspension for a period of time, or even in the most serious of cases, being struck off the roll, is appropriate. The second area that I wanted to look at was their proposal to increase their own internal fining powers. So at present, they have the ability to give internal fines of up to £2,000 for law firms and individuals. Any more than that, the case has to go to the Solicitor Disciplinary Tribunal. And what they are proposing is that the SRA's own ability to fine should be increased to £25,000. And then the final area relates to fines for law firms. And their proposal there is to take into account turnover of law firms, which they already do to a certain extent, but to increase the fines to potentially up to 5% of a law firm's turnover.
So just taking each of those in turn, do you mind just giving us a bit more of an understanding of what they're thinking? Say on the first one about fines or appropriate penalties for sexual harassment, which is obviously something that we, have to deal with a great deal in our own practice, advising clients.
Yes, so the SRA has over the last few years, partly as a result of the Me Too movement, brought a number of prosecutions in relation to sexual misconduct or sexual harassment. Most of those it succeeded, some of them it hasn't. In the cases where it has succeeded, in the majority of cases, the tribunal has fined the respondent rather than imposed a suspension from practice or a strike-off. And the fines have ranged from around £10,000 to a senior partner who touched a paralegal, social event, to £55,000, which is the highest, I believe, for a sexual harassment allegation.
Which feels incredibly out of touch with current thinking on the seriousness of these type of issues. A lot of law firm partners will, pay more for a car than they'll face in the kind of penalty, to which they might be subject for these sort of incidents. So that does feel really out of touch. And what about other regulators? What are they considering? We've talked about this in the past. What are they looking at?
Yeah, so the bar are looking at this as well, and they've already undergone a first stage consultation in which they proposed that where sexual misconduct or harassment is found proved, the sort of starting point or entry point for a sanction should be a suspension.
Right, as a starting point, right.
Yeah. And the initial response to that consultation was supportive of that position. And the SRA's provisional view, which is obviously subject to the feedback they get from the consultation, is that financial penalties are insufficient to act as a deterrent for this sort of behaviour, and that a stronger sanction is required.
Obviously, it's going to depend on the nature of the incident. However, yes, I don't know about what you think, but I would tend to agree with that. How are you going to change the culture and individual partner behaviours on a very, very modest fine?
Yes, I suppose the fine is the sort of the headline. Obviously, anyone who has to go through this process will be dragged through the tribunal, which is unpleasant, and it has a lot of impact on reputation. They would also be required to pay the SRA's costs of the proceedings, which, depending on whether or not the allegation is contested, could be substantial. all of those factors have to be taken into account as well. But I think if we're talking about sending a message as to what sort of behaviour is appropriate, then I would certainly agree that a fine isn't, to me, sending that message in a strong enough way.
Okay, so then moving on to the next area on which they're consulting.
So at present, they have the ability to fine individuals and firms up to £2,000 without having to go to the tribunal. Anything above that, or where they think a case merits a fine that's more than £2,000, it has to go to the tribunal. There is this anomaly that in relation to ABSs, they can fine managers and employees up to £50 million and firms up to £250 million. So they say that there clearly needs to be some kind of rebalancing. So what they've tried here, or proposed anyway, is that they be allowed to increase their internal fining powers to £25,000, right, so that the tribunal only needs to get involved if either the solicitor or the firm wants to appeal that decision, or if the SRA is bringing a prosecution where they think a fine of more than £25,000 is required, or obviously a more serious sanction such as a suspension or a strike-off. The rationale is that a lot of cases these days are proceeding to the tribunal by way of what's called an agreed outcome. An allegation of misconduct is made. The SRA and the firm or the individual agree the level of fine that should be paid. But because the fine is over £2,000, they then have to present that to the tribunal to effectively get the tribunal's endorsement. And they say that that whole process could be done away with, which would be quicker, it would be cheaper, it would avoid the stress to the individual or the firm of having to go before the tribunal. So it makes sense from that perspective. I think the concern is that the SRA seem to be getting quite a few things wrong at the moment in terms of the way their cases are going in the tribunal. There's a feeling perhaps that if they do impose a fine of, say, £20,000 or £25,000, a firm or an individual is looking at that and thinking, okay, well, to appeal that decision, we'll have to go to the tribunal. We'll probably incur costs of more than £25,000 doing that. Mm-hmm. We'll also have all of the time and cost expense of internal cost expense of preparing proceedings, and we probably won't recover those costs even if we do overturn the fine. So you could end up with firms sort of making commercial decisions to accept fines, which probably isn't in the public interest.
And what about the third aspect on which the SRA consulting?
The SRA have their own sort of fining bands, which they ask the tribunal to apply. And at the moment, they have a distinction between firms with turnovers of less than 2 million, where the maximum fine they can, they suggest is imposed is 50,000, mm-hmm. and firms with a turnover of more than 2 million. And in those cases, they propose a fine of 2.5% of turnover.
Currently, it's 2.5, right?
Yeah.
Okay.
That's current. And what they're suggesting is we get rid of this distinction between firms of less than 2 million and firms of more than 2 million, and we just have a system that is based on turnover, and that the percentage turnover, the fine that can be applied is up to 5% of turnover. I mean, obviously 2.5% of turnover would be a hefty fine for them as well, but doubling that would really send a message.
So it's kind of doubling it for the larger firms, but also exposing the smaller firms, the under 2 million firms, not just to the 2.5 limit, but actually to the 5%.
As you say, there are a lot of firms, smaller firms, to which this could really pinch. And obviously the larger firms as well, we could be looking at sort of substantial fines in the millions.
Yeah, I mean, this could be, in certain circumstances, apocalyptic.
Mm.
But having said that, it does bring their regime somewhat closer, say, for example, to GDPR, where they've got between 2 and 4% penalty powers, against global turnover, depending on the type of breaches. So it certainly shows the seriousness with which they're taking this, assuming that at least some, if not all of these proposals do become accepted,
Mm.
what should firms and partners be thinking about?
I think there should be a real emphasis on compliance, looking at the sort of particular risk areas for firms, which traditionally have been sort of acting in conflict situations, or using the client account as a banking facility, or acting in cases where there's been dubious financial arrangements. Those are the ones that have tended to result in the larger fines. And then obviously, when we talk about sexual harassment, then that's something more cultural that needs to happen at firms, and to really embed that into the culture.
And obviously we're seeing a number of firms considering cultural audits to try and investigate and address some of the behavioural issues and cultural issues within a firm that might be creating sort of systemic problems, but which can be addressed. And what's the timeline on the consultation if anybody would like to contribute?
It's open until the 11th of February. I would have thought anyone who has an interest in regulation should be responding. From a personal perspective, there are obviously things that are personal to individuals, such as the issue of whether fines are appropriate for misconduct. And then you've got the wider firm perspectives on SRA fining powers and the turnover fines as well. So there's lots there.
Yeah, I mean, it does seem to me that it's covering really big issues that affect all of us, within the legal sector. Whatever your size of firm, whatever area you might be in, it affects firms and their viability and behavioural issues within them. So, yeah. Thanks so much, Andrew. That's brilliant and really interesting. I hope you've enjoyed that. If you have, then please do like and share. We'd really appreciate that. And we look forward to seeing you in the next of our 10-minute talks. Thanks a lot. Take care. Bye.